Case Law Summary of Makate vs. Vodacom, Thai Limited 2016, 4, SA 121, CC. Facts of the case. The case of Makate relates to a contractual dispute between Vodacom and Mr. Makate which stems from an oral agreement that was concluded between Mr. Makate and Mr. Geisler, the Director of Product Development and Management at Vodacom. This oral agreement was later endorsed in writing by Mr. Geisler, who was at the time acting on behalf of Vodacom, and this was done via email correspondence. Mr. Makate at the time of the conclusion of the agreement was an employee of Vodacom and he was employed as a trainee accountant. He had a distance relationship with his girlfriend and they were struggling to communicate because she did not always have money to call Mr. Makate. This encouraged Mr. Makate to invent a please call me product, which would enable him to effectively communicate with each other, and he discussed this idea with his mentor who later referred him to Mr. Geisler. Before the launch of the Please Call Me product, Mr. Makate discussed the feasibility of the product with Mr. Geisler, and part of this discussion included an agreement that he, Mr. Makate, would be paid a share when the product is launched. He asked for 15%. Subsequently, they both agreed that should there be a dispute regarding the compensation, the amount to be paid to Mr. Makate would be determined by the CEO. Subsequently, there was written communication to all staff members via the newsletter which confirmed and acknowledged the main inventor of the product as Mr. Makate. In this communication, the staff were informed about the manner in which this product would be launched. However, there was another correspondence that was sent to the staff wherein it was alleged that the product was now the CEO's idea, and this was contrary to what was said before. It was also alleged that Mr. Makate stole this idea from Mountain. The product was officially launched, but Mr. Makate was not compensated. As per the terms and conditions of the agreement, Mr. Makate was not happy about this. He referred the matter to the court and he subsequently resigned at Vodacom. Legal question. 1. The main question before the Constitutional Court was whether or not Mr. Geisler had ostensible authority to conclude the agreement or contract with Mr. Makate on behalf of Vodacom, and whether or not this ostensible authority was distinct from estoppel. 2. Secondly, whether or not Vodacom was bound by the contract concluded by Mr. Geisler and whether or not the contract in question was enforceable. And 3. Thirdly, whether or not Vodacom breached the contract by failing to compensate Mr. Makate, who was entitled to such compensation in terms of the agreement. Ratio decidendi, the court's reason for its decision. The court had to deal with the issue of ostensible authority which was questioned by Vodacom. It considered previous decisions that were made by Mr. Geisler regarding new Vodacom products, his position as a board member, the power conferred to him by Vodacom to negotiate new products, the organizational structure of Vodacom and how he exercised his power, and the processes followed in implementing the new products. In the light of this, the court found that the evidence confirmed that Mr. Geisler had authority to conclude a valid contract with Mr. Makate, and this contract, according to the court, was valid and enforceable. In coming to its conclusion, the court considered the decision of the court in South African Broadcasting Corporation versus Corporation and Others 2006, 2, SA 217, SCA, in determining the issue of authority. Namely, the manner in which the processes were approved and the position held at the time of the conclusion of the contract and the manner of approving new deals. There was an issue of estoppel that was raised. For example, the issue whether or not Mr. Geisler is an agent of the principal, Vodacom could dispute the existence of the contract. The court held that the fact that the contract concluded by Mr. Makate and Mr. Geisler provided a deadlock breaking mechanism, meaning that the clause relating to, in the event of a dispute, was sufficient to enforce it. Findings. 1. Accordingly, Vodacom was bound by the contract concluded between Mr. Geisler and Mr. Makate. 2. Vodacom ought to negotiate compensation with Mr. Makate, and the same should commence such negotiations 30 days after the delivery of the judgment. 3. If the parties did not agree on the amount, the CEO should determine the reasonable amount within a reasonable time. 4. Lastly, costs for the proceedings were awarded in favor of Mr. Makate. It is important to note that there were 4 judges who did not agree with the main decision on the nature of ostensible authority, in cases where there is no actual authority, but they all concurred that their views did not affect the final judgment, but it was just a matter of interpreting the law.